Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute legal advice, professional counsel, or the establishment of an attorney-client relationship. The American legal system is complex, and laws regarding domestic relations, division, and child custody vary significantly by state and jurisdiction. The case studies and historical trends discussed herein are for illustrative purposes and do not reflect specific advice for your individual situation. You should always conduct your own due diligence and consult with a licensed, qualified legal professional in your specific jurisdiction before making any decisions regarding matrimonial or family law matters. Every 36 seconds in the United States, a marriage ends. That is roughly 2,400 divorces every single day, nearly 16,800 every week, and over 876,000 every year. While we often view these moments as personal tragedies or emotional transitions, there is a hidden, high-stakes infrastructure operating behind the scenes that turns these emotional collapses into a $50 billion annual industry. At the center of this storm sits a figure who is often part therapist, part financial forensic analyst, and part scorched earth combatant, the American divorce lawyer. Most people view the legal process of uncoupling as a simple matter of paperwork, but in reality, it is a complex chess match where the board is your future, your finances, and your relationship with your children. If you walk into a courtroom or a mediation suite without understanding the mechanics of how these professionals operate, the incentives that drive their billing cycles, and the specific archetypes of legal representation available to you, you are essentially entering a high-stakes casino where the house always wins. This deep dive masterclass is designed to solve one of the most stressful and opaque problems facing the modern American adult: how to navigate the American divorce industry without losing your sanity or your life savings. We are going to peel back the curtain on the divorce industrial complex to show you exactly how the system is structured. Over the course of this series, we will explore why certain lawyers prioritize conflict over resolution, how the billable hour can be both a tool for justice and a weapon for financial depletion, and how you can identify the difference between a representative who wants to solve your problem and one who wants to fund their next vacation with your legal fees. This is not a guide on how to win a fight. It is an educational blueprint on how the system works so you can make informed, objective decisions during one of the most subjective periods of your life. To understand the current state of the American divorce lawyer, we have to look at the massive shift in historical trends that occurred in the late 20th century. Before 1969, getting a divorce in the United States was a grueling process that required proving fault. You had to demonstrate adultery, cruelty, or abandonment. This created a legal environment where lawyers were essentially private investigators, digging for dirt to prove a moral failure. Everything changed when California signed the Family Law Act of 1969, ushering in the era of no-fault divorce. On the surface, this was designed to reduce conflict and simplify the process. In reality, it shifted the battleground from "why is this happening?" to "how do we split the loot?" This transition created a new breed of legal professional, the matrimonial strategist. In the modern U.S. landscape, the divorce lawyer operates within a framework of equitable distribution or community property, depending on the state. This is where the complexity begins. In a community property state like California or Texas, the law generally views all assets acquired during the marriage as owned 50-50. It sounds simple until you involve a family-owned business, stock options that haven't vested yet, or the intellectual property of a side hustle. This is where the American divorce lawyer earns their keep. They are tasked with valuing things that are inherently difficult to value. For example, consider a case study involving a spouse who stayed home to raise children, while the other built a medical practice. How do you value the enhanced earning capacity of that medical degree? How do you quantify the professional sacrifice of the stay-at-home parent? The lawyer must navigate these gray areas using historical trends and actuarial data to argue for potential outcomes that favor their client. One of the most misunderstood aspects of this profession is the incentive structure. Most American divorce lawyers work on a billable hour model, often requiring an upfront retainer that can range from $3,500 for a simple case to upwards of $50,000 for high-net-worth individuals. This retainer acts as a down payment on the lawyer's time. As they respond to emails, file motions, and attend hearings, they draw down from this fund. This creates an inherent tension in the legal process. If a case is resolved quickly through mediation, the lawyer bills fewer hours. If a case becomes a protracted, 3-year litigation battle with multiple experts and depositions, the lawyer bills more. This does not mean every lawyer is trying to stir the pot, but the system itself does not financially reward a quick resolution. Understanding this incentive is vital for any consumer of legal services. You need to know that every angry email you ask your lawyer to send to your ex-spouse is essentially a $150 to $300 line item on your monthly invoice. Furthermore, we must examine the different archetypes of the American divorce lawyer. There is the pit bull, the lawyer known for aggressive litigation and a refusal to back down. This archetype is often sought after by clients who feel wronged or who are dealing with a narcissistic partner. However, historical trends suggest that scorched earth tactics often result in higher legal fees and more emotional trauma for any children involved, without necessarily yielding a significantly better financial outcome. Then there is the mediator or collaborative lawyer, who focuses on interest-based negotiation. Their goal is to keep the parties out of the courtroom entirely. In the US, about 90 to 95% of divorce cases eventually settle before trial, meaning that for the vast majority of people, the pit bull approach is often an expensive performance that ends in the same settlement a mediator could have reached for a fraction of the cost. The American divorce lawyer also has to manage the three-body problem of family law: the emotional, the financial, and the legal. A common mistake viewers make is using their lawyer as a therapist. While a lawyer needs to understand the emotional context of a case, their hourly rate is significantly higher than that of a licensed counselor. When a client spends 45 minutes on the phone crying about an affair, the lawyer is still billing their standard rate. Educational data shows that the most successful clients, those who emerge from the process with the most assets and the least stress, are those who treat the divorce as a business transaction. They use therapists for the emotional work and lawyers for the technical legal work. As we move forward in this series, we will look at the specific tools these lawyers use, from requests for production, where they can force an ex-spouse to turn over every bank statement and text message from the last decade, to depositions where testimony is taken under oath in a conference room. We will also look at how the digital age has changed the game. Today, an American divorce lawyer is often part digital forensic expert, looking through social media posts, Venmo transactions, and even Netflix watch histories to build a case regarding a spouse's lifestyle or fitness as a parent. We will break down the exact steps of a standard filing, the strategic timing of serving papers, and the temporary orders phase, which often sets the tone for the next 2 years of a person's life. This is a deep dive into a world that most people hope they never have to enter, but which everyone should understand, because in the American legal system, knowledge isn't just power. It is the only thing protecting your future. To understand how the American divorce lawyer begins their work, we must look at the first 90 days of a case, a period often referred to in legal circles as the strategic positioning phase. Imagine a couple in 2026. Let us call them Alex and Jordan. Alex is a senior software architect earning $250,000 a year, while Jordan has spent the last decade managing the household and running a boutique consulting firm that nets $40,000. When Alex decides to file for divorce, the very first document their lawyer prepares is the summons and petition for dissolution of marriage. This is not just a notice of intent. It is a jurisdictional land grab. By filing first, Alex chooses the venue. In the United States, if a couple owns property in both New York and Florida, the laws governing how that property is divided differ wildly. Filing in one state over another can result in vastly different potential outcomes regarding the duration of alimony or the classification of premarital assets. Historical trends show that the spouse who secures the preferred venue often gains a psychological and financial head start that persists through the entire litigation process. Once the petition is served, Jordan's lawyer must file an answer and counterclaim within a strict window, usually 20 to 30 days. This is where the legal chess match moves from theory into high-speed action. The most critical early move in any American divorce case is the motion for temporary orders, also known as pendant light relief. In our 2026 scenario, Jordan cannot wait 2 years for a final trial to determine how to pay the mortgage or who gets to drive the primary family vehicle. Jordan's lawyer will file a motion asking a judge to establish a status quo. This involves a hearing where the judge decides on a temporary basis who stays in the marital home, who pays the utility bills, and what the initial parenting schedule will look like. Historical data suggests that these temporary orders are the most influential documents in the entire case. Because courts are backlogged and judges prefer stability, a temporary order established in month 2 often becomes the blueprint for the final settlement in month 24. If Jordan's lawyer fails to secure enough temporary support to maintain the household, Jordan may be forced into a predatory settlement early on simply because they cannot afford to keep the lights on while the case proceeds. This leads us into the most labor-intensive and expensive phase of the American divorce machine, discovery. In 2026, discovery has been transformed by the integration of artificial intelligence and deep-link financial auditing. The divorce lawyer's primary weapon here is the request for production of documents. This is a formal legal demand for every scrap of paper and every byte of data related to the couple's life. We are talking about 5 years of tax returns, bank statements for every account held individually or jointly, credit card statements, investment portfolios, retirement account summaries, and even cryptocurrency wallet addresses. For a high net worth individual like Alex, this list might extend to several hundred specific items. The lawyer's goal is to create a complete financial map. If Alex has been funneling money into a separate account or overpaying the Internal Revenue Service to create a hidden refund asset for the following year, a skilled lawyer using forensic tools will flag these anomalies. Beyond the paper trail, the lawyer utilizes interrogatories. These are written questions that the opposing spouse must answer under oath. Examples include asking for a detailed list of all gifts given to third parties exceeding $500, or a complete history of any business interests acquired during the marriage. If Alex lies in these documents, the potential outcomes include the judge awarding a larger share of the marital estate to Jordan as a penalty for fraud on the court. In many U.S. jurisdictions, hiding assets is treated with extreme severity. There are case studies where a spouse who hit a lottery win or a secret investment was ordered by the court to forfeit 100% of that specific asset to the other spouse, once the deception was uncovered during discovery. The centerpiece of this phase is the financial affidavit or statement of net worth. This is a sworn document where each spouse lists their monthly income, their monthly expenses, their assets, and their debts. For the American divorce lawyer, this document is the foundation of their entire strategy. They look for lifestyle inflation or lifestyle depression. If Alex claims their monthly expenses are $10,000, but their disclosed income is only $8,000, the lawyer will demand to know where the extra $2,000 is coming from. Conversely, if Jordan suddenly claims to spend $3,000 a month on household maintenance, when historical trends in their bank statements show they previously spent only $500, Alex's lawyer will move to strike those expenses as an attempt to artificially inflate the need for alimony. Step by step, the lawyer then moves to third-party discovery. They issue subpoenas to employers for payroll records and bonus structures. They subpoena banks for canceled checks to see exactly where money was spent. In 2026, this frequently includes subpoenas to social media platforms and communication apps. If Alex told the court they were broke and couldn't afford temporary support, but their Instagram shows them on a luxury ski trip in Aspen, Jordan's lawyer will use those timestamps and geotags to impeach Alex's credibility in open court. Credibility is the only currency that truly matters in a courtroom. Once a lawyer proves a spouse has lied about a small detail, the judge is statistically much more likely to doubt their testimony on larger issues like child custody or the valuation of a private business. While the paperwork blizzard continues, the lawyer is also managing the dissipation of assets claim. Dissipation occurs when one spouse uses marital funds for a non-marital purpose, while the marriage is undergoing an irreconcilable breakdown. Common examples found in U.S. case studies include spending money on a new partner, gambling losses, or sudden, large loans to family members that are never intended to be repaid. If Alex took $50,000 from a joint savings account to buy a luxury watch after the date of separation, Jordan's lawyer will argue that this was a dissipation of the marital estate. The lawyer will then ask the court to credit that $50,000 to Alex's side of the ledger in the final distribution, meaning Jordan gets $50,000 more of the remaining assets to balance the scales. The sheer volume of data in a modern U.S. divorce creates a phenomenon known as litigation by attrition. This is a tactic where one lawyer overwhelms the other with thousands of pages of unorganized documents, hoping the other side will miss a key detail or simply run out of money to pay their own lawyer to review it all. In 2026, a top-tier divorce lawyer counters this by using AI-driven litigation support software that can categorize and cross-reference these documents in real time. They look for the gap, the difference between what a spouse says they have and what the data shows they should have. However, as the discovery phase winds down, the focus shifts from finding the money to valuing it. This is where the divorce lawyer stops being a clerk and starts being a negotiator. They have to decide if a $1 million house with a $600,000 mortgage is worth more or less than a $400,000 401k plan. Because of tax implications, which we will dive into later, these two assets are not equal. One carries a massive future tax liability, while the other provides immediate shelter and potential equity growth. If a lawyer doesn't understand the tax code of 2026, they can inadvertently cost their client hundreds of thousands of dollars in a 50-50 split that is actually 40-60 after the government takes its share. The tension of discovery often pushes the parties toward the next major hurdle, the deposition. This is a live, recorded session where one lawyer grills the other spouse for hours, sometimes days, under oath. It is the most high-pressure moment outside of an actual trial, and it often reveals the smoking gun that ends the case. But what happens when the money isn't just in a bank account? What happens when the primary asset is a complex business or a professional practice that one spouse claims is worth nothing, but the other claims is worth millions? And how does the lawyer handle the most volatile element of all, the custody of children, when it is being used as a bargaining chip for financial gain? We will explore the brutal mechanics of business valuations and the psychological warfare of custody evaluations in the next part of this dive. When the American divorce lawyer shifts focus from liquid bank accounts to the valuation of a private business, the litigation enters its most technically demanding phase. For our couple, Alex and Jordan, the fact that Alex owns a specialized software architecture firm complicates the division of assets significantly. In the United States legal system, a business is not just an income stream. It is a marital asset subject to distribution if it was started or grew in value during the marriage. To determine what Jordan is owed, the lawyers must first determine what the business is worth, a process that relies on three primary methodologies: the asset-based approach, the market approach, and the income approach. The asset-based approach is the most straightforward, but often the least favorable for a service-based business like Alex's. It essentially calculates the value by subtracting the company's liabilities from the fair market value of its tangible assets. If Alex's firm only owns 5 high-end laptops and a leased office space, this method might suggest the business is worth very little. However, Jordan's lawyer will push for the income approach, specifically the capitalized cash flow method. This involves taking the historical earnings of the business, adjusting them for non-recurring expenses or personal perks, like Alex's company car or high-end travel, and then applying a capitalization rate to predict future earnings. This turns a firm with $10,000 in physical assets into a marital asset worth millions of dollars on paper. A critical point of contention that every top-tier divorce lawyer must navigate is the concept of goodwill. Historical trends in U.S. family law distinguish between enterprise goodwill and personal goodwill. Enterprise goodwill is the value that exists within the business itself, such as the brand name, the proprietary code, or the recurring client contracts that would remain even if Alex left the company. Personal goodwill is the value tied directly to Alex's individual reputation, skills, and relationships. In many states, personal goodwill is not considered a marital asset because it cannot be sold or transferred. It is essentially Alex's future earning capacity. The legal battle here becomes a forensic fight. Jordan's lawyer will hire a forensic accountant to argue that the company's success is due to its brand and systems, making it enterprise goodwill that can be split. Alex's lawyer will argue that if Alex stops working, the business vanishes, meaning it is all personal goodwill and should be excluded from the pot. This leads into the complex problem of double dipping. Imagine if the court values Alex's business at $2 million and awards Jordan $1 million as their share of the asset. Then, the court looks at Alex's high income from that same business to calculate alimony. Alex's lawyer would argue that the court is counting the same money twice, once as an asset to be divided and once as income to be taxed for support. Different states have different potential outcomes for this. Some jurisdictions explicitly forbid double dipping, while others allow it under certain equitable circumstances. The forensic accountant becomes the most important person in the room here, using 2026 data analytics to separate the salary Alex earns from the profit the business generates. While the financial experts are arguing over spreadsheets, the divorce lawyer is often simultaneously managing the most volatile part of the case: child custody. In the United States, the universal standard is the best interests of the child. This sounds simple, but in practice, it is a vague and highly subjective framework that allows for intense psychological warfare. To provide clarity, the court often appoints a guardian ad litem, or a forensic custody evaluator. These professionals are usually psychologists trained to conduct deep dive investigations into the lives of the parents. In our 2026 scenario, the custody evaluator might spend 40 to 60 hours interviewing Alex and Jordan, observing them with their children and speaking with teachers, doctors, and even neighbors. They often utilize psychological testing, such as the Minnesota Multiphasic Personality Inventory, to look for underlying personality disorders or behavioral risks. For the lawyers, this phase is about narrative control. If Jordan's lawyer can demonstrate a historical trend of Alex being physically absent due to work travel, they may push for Jordan to have primary physical custody. Alex's lawyer, conversely, might use digital evidence from 2026 smart home devices or shared calendar apps to show that Alex was the one handling the morning routines and medical appointments, regardless of their work schedule. The psychological warfare often centers on accusations of parental alienation or gatekeeping. This occurs when one parent is accused of systematically undermining the child's relationship with the other parent. Lawyers must be extremely careful here. While these accusations are common, they are difficult to prove and can backfire. If a judge perceives that Alex is making false accusations of alienation just to gain leverage, Alex risks losing custody altogether. The legal strategy involves documenting every missed phone call, every late pickup, and every disparaging text message. In 2026, the use of specialized co-parenting apps is often mandated by the court, creating a permanent, uneditable record of all communication that lawyers can later use as exhibits in a custody hearing. There is a cynical reality that professional divorce lawyers must address: the use of custody as a financial bargaining chip. Because child support in most U.S. states is calculated using a formula that includes the number of overnights each parent has, there is a direct financial incentive to fight for more time. If Alex can secure a 50-50 split of time, the child support obligation might be significantly lower than if Jordan has 60% of the time. This creates a situation where parents are fighting over a single Wednesday night, not because of the quality of time with the child, but because that one night shifts the percentage enough to save thousands of dollars a year in support payments. A skilled lawyer must help their client navigate this without appearing heartless to a judge who is focused solely on the child's well-being. Furthermore, we are seeing new trends in 2026 regarding the impact of remote work on custody. If Alex's software firm allows them to work from anywhere, Alex might want to move to a state with lower taxes or a lower cost of living. This triggers a relocation or removal case, which is one of the most difficult types of litigation for a divorce lawyer. The lawyer must prove that the move provides a significant benefit to the child, not just a financial benefit to the parent. They must present a detailed parenting plan showing how the other parent will maintain a meaningful relationship across state lines, often involving expensive travel arrangements and virtual visitation schedules. As the discovery of business assets concludes and the custody evaluators finalize their reports, the case reaches a boiling point. The legal fees have likely reached six figures, and the emotional toll is peaking. This is the moment where the lawyer's role shifts from a combatant to a closer. They must now take all this data, the business valuations, the psychological profiles, the tax implications, and package it for the most critical meeting of the entire process. Before a case ever sees the inside of a courtroom for a final trial, it must pass through the gauntlet of mandatory mediation and settlement conferences. In the next part, we are going to look at the high-stakes world of the settlement room. We will explore the specific negotiation tactics lawyers use to force a deal, the role of the retired judge acting as a mediator, and the alimony math that decides how much of your future income is actually yours to keep. We will also break down the specific language in a marital settlement agreement that can either protect you for decades or leave you vulnerable to endless future litigation. What happens when the person you once loved becomes your greatest legal adversary, in a room with no windows and a ticking clock? The answer lies in the art of the deal. The mediation suite in 2026 is often a sterile, high-rise office designed to facilitate the death of a marriage through structured compromise. For Alex and Jordan, this is the most critical day of their legal journey. In the United States, many jurisdictions now mandate mediation before a case can even be placed on a trial docket. This is not because the system believes in reconciliation, but because the system is overwhelmed. Without mediation, the family court infrastructure would collapse under the weight of nearly 1 million annual filings. The central figure in this room is the mediator, often a retired judge or a senior attorney who has seen thousands of versions of the same story. Their role is not to decide who is right, but to find the intersection of what both parties are willing to tolerate. The process typically begins with shuttle diplomacy or caucusing. Alex and Jordan are placed in separate rooms, often at opposite ends of a hallway. This physical separation is a strategic choice by the lawyers to minimize emotional volatility. If Alex and Jordan are in the same room, the conversation often devolves into historical grievances about who forgot an anniversary in 2018. In separate rooms, the lawyers can keep the focus on the spreadsheets. The mediator moves back and forth, carrying offers and counteroffers like a high-stakes courier. This creates a psychological environment known as the sunk cost pressure. By the time hour 6 or 7 rolls around, the parties are exhausted, hungry, and staring at mounting legal bills. The mediator uses this fatigue as a tool to push for closure. In our 2026 scenario, the negotiation starts with the low-hanging fruit. These are the assets with clear, undisputed values: the secondary bank accounts, the vehicles, and the household furniture. Lawyers use these easy wins to build momentum. However, the atmosphere shifts when the conversation moves to the spousal support or alimony math. In the United States, alimony has undergone a radical transformation in the last decade. Since the federal tax changes that took effect in 2019 and have solidified through 2026, alimony is no longer tax-deductible for the person paying it, nor is it taxable income for the person receiving it. This shifted the historical trends of negotiation. Before 2019, a lawyer might suggest Alex pay a higher amount of alimony because Alex could write it off, effectively having the government subsidize part of the divorce. Now, every dollar Alex pays is a net after-tax dollar. To calculate the potential outcomes for alimony, the lawyers and mediator look at several factors: the length of the marriage, the standard of living established during the union, and the earning capacity of each spouse. Jordan's lawyer will argue for rehabilitative alimony, a form of support designed to provide Jordan with enough capital to go back to school or rebuild their consulting firm to a self-sustaining level. Alex's lawyer will push for durational alimony, which has a hard end date and is strictly limited by the number of years the marriage lasted. In many U.S. states, if a marriage lasted less than 7 years, alimony might not even be on the table. If it lasted over 20, it could potentially be permanent, though that historical trend is rapidly disappearing in favor of term-limited support. As the mediator enters Alex's room, they might use a technique called reality testing. They will tell Alex that if the case goes to trial, a judge might look at Alex's $250,000 salary and Jordan's $40,000 earnings and order a support payment that is far higher than what Jordan is currently asking for. Simultaneously, the mediator goes to Jordan's room and warns that a judge might find Jordan is underemployed and impute an income to them, meaning the court would treat Jordan as if they were earning $60,000 instead of $40,000, thereby lowering the alimony. This dual pressure tactic is designed to make both parties feel that a voluntary settlement is safer than a judicial lottery. One of the most complex negotiation points involves the trade-off between different types of assets. This is known as log rolling. Imagine if the marital home has $400,000 in equity and Alex's retirement account has $400,000 in value. On the surface, it looks like a simple swap. But a professional divorce lawyer in 2026 knows that these are not equal. The house is a post-tax asset with maintenance costs, property taxes, and potential selling commissions. The retirement account, if it is a traditional 401k, is a pre-tax asset that will be taxed heavily when the money is eventually withdrawn. If Jordan takes the house and Alex takes the retirement account, Jordan is actually receiving more value today, while Alex is receiving a future liability. The lawyer must use a present value calculation to ensure the deal is equitable. If a settlement is reached, the lawyers begin drafting the Marital Settlement Agreement, or MSA. This document is a comprehensive contract that will eventually be incorporated into the final judgment of dissolution. In 2026, these documents are incredibly detailed, often running 50 to 100 pages. They must cover every possible future conflict. For example, who pays for the children's orthodontic work in 2029? If Alex's software firm is sold in 2030, does Jordan get a piece of that sale? The lawyer must include specific language regarding the non-modifiability of certain provisions. If the alimony is non-modifiable, it means even if Alex loses their job tomorrow, they are still legally obligated to pay the full amount. A critical and often overlooked part of the MSA is the security for support. If Alex is ordered to pay Jordan $3,000 a month for the next 10 years, what happens if Alex passes away in year 3? A skilled divorce lawyer will require Alex to maintain a life insurance policy with Jordan named as the beneficiary to secure those future payments. They will also include a right to audit clause, allowing Jordan to see Alex's tax returns every year to ensure that if Alex's income increases significantly, Jordan can file for a modification of child support based on the updated data. However, the most dangerous part of the settlement room is the pressure to sign. Once the mediator has ground both sides down, they often produce a term sheet or a memorandum of understanding. In many jurisdictions, once this summary is signed, it becomes a binding contract, even before the formal MSA is typed up. Many people experience buyer's remorse the next morning, but in the American legal system, it is notoriously difficult to overturn a signed settlement agreement unless you can prove actual fraud or duress. The lawyer's job is to ensure their client understands that the pen they are holding is a permanent tool of change. What if the negotiation fails? What if Alex refuses to share the business and Jordan refuses to budge on the house? Then the case moves toward the most expensive, most public, and most unpredictable phase of the entire process: the trial. Most people think they want their day in court until they realize what that actually entails. We are talking about cross-examination, public disclosure of private secrets, and a total loss of control over the outcome. In the next part, we will step inside the courtroom. We will break down how a trial actually works, how lawyers prepare their witnesses to handle the heat of the stand, and the specific ways a judge decides your future when you can't decide it for yourself. We will also examine the shocking costs of a full-scale legal war, and why the only real winners are often the people in the suits. The transition from the quiet mediation room to the public courtroom changes everything. The transition from the quiet mediation room to the public courtroom changes everything. When a divorce moves to trial in the United States, the level of formality and the stakes increase exponentially. For Alex and Jordan in 2026, the failure of mediation means their private lives are about to be laid bare in a public record. In the American legal system, family law trials are bench trials, meaning there is no jury of peers. Your fate, your finances, and your family structure are decided by a single person: the judge. This individual has seen thousands of cases and is often operating in a high-volume, high-stress environment. The primary goal of the American divorce lawyer at this stage shifts from negotiation to the aggressive presentation of evidence under strict procedural rules. The preparation for a trial begins months in advance with the creation of the trial notebook. This is a massive, often digital repository that contains every exhibit, every witness list, and every piece of discovery gathered over the previous year. For Alex, whose software firm is at the center of the financial dispute, the lawyer must prepare a detailed exhibit list that includes tax returns, profit and loss statements, and the forensic accountant's valuation report. Step by step, the lawyer must ensure that every document is authenticated. In a 2026 courtroom, this often involves digital forensics experts who can testify that the bank records and text messages presented are genuine and have not been altered. Historical trends show that a trial's outcome is often decided by which lawyer is more organized. If a lawyer cannot find a specific document when the judge asks for it, the momentum shifts instantly. The trial begins with the opening statement. Unlike a criminal trial where the goal is to prove guilt beyond a reasonable doubt, a divorce trial operates on the preponderance of the evidence standard. This means the judge only needs to believe that your version of the facts is more likely true than not, essentially a 51% certainty. The lawyer uses the opening statement to frame the narrative. For Jordan's lawyer, the narrative might be one of sacrifice. Jordan gave up a career to build the home that allowed Alex to build a firm. For Alex's lawyer, the narrative is one of individual contribution. The firm's success is due to Alex's unique intellectual property, which should be protected as separate property. Once opening statements conclude, the petitioner, the person who filed first, presents their case in chief. This involves direct examination of witnesses. When Jordan's lawyer calls Jordan to the stand, they use open-ended questions: who, what, where, when, and why. The goal is to let Jordan tell a story that evokes empathy while grounding it in facts. However, the opposing lawyer is constantly watching for violations of the rules of evidence. If Jordan tries to testify about what a neighbor said regarding Alex's late-night work habits, Alex's lawyer will immediately object on the grounds of hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted, and in a 2026 courtroom, it is the most common reason testimony is thrown out. Then comes the most dramatic part of the trial: cross-examination. This is where the American divorce lawyer earns their reputation. Cross-examination is not about asking questions. It is about making statements that the witness must agree with. The lawyer uses leading questions that only allow for a yes or no answer. Imagine Alex on the stand being grilled by Jordan's lawyer about hidden offshore accounts. The lawyer does not ask, "Where is the money?" Instead, they ask, "You opened a bank account in the Cayman Islands on June 14, 2024, correct? You did not disclose this account on your initial financial affidavit, correct?" This process is designed to impeach the witness's credibility. If the lawyer can prove Alex lied about one bank account, the judge may discount Alex's entire testimony regarding the valuation of the business. In 2026, expert witnesses play a decisive role in the courtroom. Forensic accountants are called to the stand to explain complex valuation methodologies to a judge who may not have a background in finance. The lawyer must lead the expert through their qualifications to establish them as an authority. Then the expert explains their findings. Case studies in high-net-worth divorces show that when two experts provide wildly different valuations for the same business, the judge often takes a split-the-baby approach, or worse, sides with the expert who was the most coherent and least defensive during cross-examination. The lawyer's job is to prep their expert to remain calm when the opposing counsel tries to poke holes in their math or suggests they are simply a hired gun for their client. The psychological toll of a trial is often underestimated. Because the proceedings are public, anyone can walk into the gallery and listen. In some high-profile cases, the transcripts are picked up by local media. For Alex and Jordan, this means their parenting failures, their financial mistakes, and their private arguments are now part of a permanent, searchable public record. This dirty laundry factor is a strategic tool used by lawyers to force a last-minute settlement on the courthouse steps. Many clients who were adamant about having their day in court suddenly change their minds when they see their ex-spouse lawyer holding a stack of embarrassing text messages, ready to be entered into evidence. The financial cost of a trial is staggering. In the United States, a full-scale divorce trial can cost between $25,000 and $100,000 per side in additional legal and expert fees alone. Lawyers often bill for trial days in 12-hour blocks, including evening preparation. Every hour spent in the courtroom is an hour where the meter is running at $400 to $800 per hour. For many middle-class families, the cost of the trial itself can consume a significant portion of the equity they are fighting over. Historical trends suggest that by the end of a 3-day trial, the parties have often spent more on lawyers than the value of the assets they were disagreeing about in the first place. After all witnesses have testified and all evidence has been admitted, the lawyers give their closing arguments. This is the final pitch to the judge, summarizing the evidence and applying it to the state's specific statutes. In 2026, lawyers often provide the judge with the proposed judgment, which is a document written exactly how the lawyer wants the judge to rule. If the judge is impressed with the lawyer's logic and the clarity of the evidence, they may simply sign the proposed judgment with minor edits. However, the judge rarely rules immediately. Most judges will take the case under advisement, meaning Alex and Jordan will have to wait weeks, sometimes months, for a written decision to arrive in the mail. This period of the wait is often the most stressful part of the entire process. When the judgment of dissolution finally arrives, it is a cold, clinical document that dictates where the children will sleep, how much money will be transferred between bank accounts, and how the retirement funds will be carved up. But even a final judgment isn't always the end. In the American legal system, the issuance of a judgment triggers a new set of deadlines and a new phase of the legal machine. What happens if the judge made a mistake of law? What if one spouse refuses to follow the court's orders, leading to contempt of court? And perhaps most importantly, how do you actually move the money from one person's name to another without triggering a massive tax bill from the IRS? In the next part, we will dive into the world of post-judgment enforcement and the complex qualified domestic relations orders that act as the final bridge to your new life. We will also explore the rarely discussed world of appeals, where the battle moves from the local courtroom to a higher court of review. The war may be over, but the reconstruction is just beginning. The war may be over, but the reconstruction is just beginning. In the American legal system, receiving a signed judgment of dissolution is not the final step. It is merely the acquisition of a legal license to begin the complex process of asset migration and enforcement. For Alex and Jordan in 2026, the piece of paper signed by the judge does not automatically move a single cent from Alex's retirement account into Jordan's name, nor does it physically remove Alex's name from the mortgage of the marital home. This post-judgment phase is where many people experience a secondary wave of legal fees and administrative frustration, as they realize that the court's order is often only as strong as the secondary documents required to implement it. The most technically demanding part of this reconstruction involves the Qualified Domestic Relations Order, or QDRO. Imagine if the judge ordered Alex to give Jordan $400,000 from a 401k account. In the United States, if Alex simply withdrew that money and wrote Jordan a check, the IRS would view it as a premature distribution. Alex would be hit with an immediate 20% federal tax withholding and a 10% early withdrawal penalty if they are under age 59 and a half. To avoid this financial catastrophe, the American divorce lawyer must facilitate a QDRO. This is a specialized court order, often drafted by a third-party specialist rather than the primary divorce lawyer, that instructs the plan administrator of the retirement fund to segregate a portion of the account for the alternate payee, in this case Jordan, without triggering taxes or penalties. The step-by-step process for a QDRO in 2026 is rigorous. First, the specialist drafts the order based on the specific language of the divorce judgment. Second, this draft is sent to the plan administrator for pre-approval to ensure it meets the specific requirements of that corporation's retirement plan. Third, once pre-approved, the order is submitted to the judge for a signature. Finally, the certified order is sent back to the plan administrator for execution. This process can take anywhere from 3 to 9 months. During this window, Jordan is in a state of financial limbo, waiting for the assets to be officially moved into a separate rollover IRA. Historical trends show that many individuals fail to complete this step, leaving their retirement security tied to an ex-spouse's employer for years after the divorce, which creates massive legal headaches if the ex-spouse dies or retires before the QDRO is processed. Next, we must look at the real estate transition. In our 2026 scenario, if Jordan was awarded the marital home, the judgment likely requires Alex to sign a quitclaim deed. This document transfers Alex's ownership interest to Jordan. However, signing the deed does not remove Alex from the mortgage. In the United States, a mortgage is a contract with a bank that is independent of a divorce decree. If Jordan stays in the house but fails to pay the mortgage, the bank will still pursue Alex for the debt and Alex's credit score will be decimated. To solve this, the judgment usually requires Jordan to refinance the mortgage into their own name within a specific time frame, such as 90 days. In the 2026 economic environment, where interest rates may be significantly higher than when the original mortgage was signed, Jordan might find it impossible to qualify for a new loan on a single income. If the refinance fails, the lawyer must then execute the backup provision of the judgment. The house must be sold on the open market and the proceeds divided. This often leads to a secondary round of conflict over the listing price and which real estate agent to hire. For Alex, the business owner, the post-judgment phase involves the delicate task of buying out Jordan's interest in the software firm. If the judge valued Jordan's share at $500,000, but the business does not have that much cash on hand, the lawyer must structure a settlement note. This is essentially a private loan where Alex pays Jordan in installments over several years, secured by the assets of the business. The lawyer must draft a promissory note and a security agreement. If Alex misses a payment, Jordan has the legal right to seize business equipment or even place a lien on the company's future revenue. These arrangements turn ex-spouses into involuntary business partners for years, a situation that requires precise legal language to prevent Alex from tanking the business to avoid making payments. What happens when an ex-spouse simply refuses to follow the order? This brings us to the mechanism of enforcement and contempt of court. In the U.S., if Alex stops paying the court-ordered alimony, Jordan's lawyer does not call the police. They file a motion for contempt. To succeed, the lawyer must prove that there was a clear court order, that Alex had the ability to comply, and that Alex willfully violated it. Historical trends in family law indicate that ability to pay is the primary battleground. If Alex can prove they lost their job or suffered a medical emergency, the court may not find them in contempt, though the debt will still accrue as arrears. If the court does find Alex in contempt, the judge can issue a purge amount, a specific sum of money Alex must pay immediately to stay out of jail. In extreme cases, the American legal system allows for the suspension of driver's licenses, the seizure of passports, and the garnishment of tax refunds to satisfy unpaid support obligations. In 2026, the use of income withholding orders or IWOs has become the standard for child support. This bypasses the need for Alex to write a check altogether. The order is sent directly to Alex's employer, who deducts the support from Alex's paycheck and sends it to a state disbursement unit, which then forwards the funds to Jordan. This reduces conflict and ensures a clear record of payment, But it also means that Alex's employer is now fully aware of the details of their personal litigation, which can have professional repercussions in high-stakes corporate environments. However, some parties choose to fight the judgment itself through an appeal. In the United States, you generally have a strict 30-day window from the date of the final judgment to file a notice of appeal. It is critical to understand that an appeal is not a new trial. You cannot introduce new evidence or call new witnesses. The appellate court only looks at the record, the transcripts of the trial and the exhibits, to determine if the trial judge made a reversible error of law or an abuse of discretion. Case studies show that appeals are statistically difficult to win. The appellate court gives great deference to the trial judge's findings of fact, because the trial judge was the only one who saw the witnesses testify in person. An appeal can cost an additional $15,000 to $50,000 and take over a year to resolve, during which time the original judgment may or may not be stayed or paused. As we conclude this part of the reconstruction, we see that the American divorce lawyer's role is as much about paperwork as it is about persuasion. The shift from the heat of the courtroom to the cold reality of asset transfers is where many people lose their stamina. But even once the money is moved and the deeds are signed, the most complex system of all remains active: the co-parenting relationship. The legal system has set the rules, but life in 2026 is unpredictable. What happens when a parent wants to move across the country for a new job? What happens when a child refuses to follow the court-ordered schedule? In the next part, we will explore the high-stakes world of post-judgment modifications and the legal battles over parental relocation. We will dive into how the system handles change of circumstances and why the divorce decree is often just the first version of a living document that will evolve for the next 18 years. The ink might be dry, but the story is far from over. The reality of the American legal system is that a divorce decree involving children or long-term financial support is rarely a static finish line. Instead, it functions as a living document that must breathe and adapt as the lives of the parties evolve. In the United States, this is governed by the legal principle of a material and substantial change in circumstances. This threshold is the gatekeeper of the post-judgment world. You cannot simply return to court because you are unhappy with the original deal, or because you have a minor disagreement with your ex-spouse. To reopen the case for a modification of support or custody, an American divorce lawyer must first prove to a judge that something fundamental has shifted since the day the final judgment was signed. Imagine it is late 2026, and Alex, our software architect, faces a significant professional hurdle. Perhaps the specific niche of software architecture Alex specialized in has been disrupted by a new wave of autonomous coding agents, leading to a legitimate and involuntary decrease in income from $250,000 to $120,000. This is a classic example of a substantial change. Alex's lawyer would file a supplemental petition for modification of child support and alimony. The timing of this filing is statistically critical. In most U.S. jurisdictions, the court does not have the authority to retroactively reduce support. If Alex waits 6 months to file while struggling to pay the old amount, those 6 months of overpayments or arrears are legally locked in. Potential outcomes for Alex depend on proving that the income loss was not a voluntary attempt to shirk financial obligations, a tactic sometimes referred to as voluntary impoverishment. Conversely, consider the scenario from Jordan's perspective. If Jordan's consulting firm, which was valued at a modest amount during the divorce, suddenly secures a multi-million-dollar contract in 2026, Alex's lawyer might seek to terminate or reduce the alimony payments. The argument here is that the original need for support has been extinguished by Jordan's newfound self-sufficiency. However, historical trends in family law suggest that courts are often hesitant to punish a recipient spouse for their post-divorce success, unless the original agreement was structured as modifiable. This highlights why the specific language drafted by the lawyers in the original marital settlement agreement is so vital. If the agreement stated the alimony was non-modifiable, Jordan's windfall is protected. If that one word was missing, the legal battle begins anew. The most explosive and litigated area of post-judgment law in the United States is parental relocation, often called a move-away case. In our modern mobile society, it is common for a parent to receive a job offer or seek a lower cost of living in a different state. However, if that parent has joint custody, they cannot simply pack the car and leave. Most U.S. states have strict relocation statutes requiring a parent to provide formal notice if they intend to move more than 50 or 100 miles away. If the other parent objects, the case enters a high-stakes evidentiary hearing that is essentially a second custody trial. In a 2026 relocation case, the lawyer must navigate a complex multi-factor test. The court will look at the child's relationship with the non-relocating parent, the child's age and developmental needs, and whether the move will actually improve the child's quality of life. Imagine Jordan wants to move the children from a high-cost city like Seattle to a smaller town in North Carolina to be closer to family and reduce expenses. Jordan's lawyer must present a detailed plan showing how the children will maintain their relationship with Alex. This might include longer summer blocks of time, alternating holidays, and the use of high-fidelity virtual visitation technology that has become standard by 2026. The lawyer must also prove that the move is not being made in bad faith to frustrate Alex's parenting time. Historical trends show that relocation cases are among the most difficult to predict, as judges must balance the constitutional right to travel with the child's right to have both parents actively involved in their lives. As children grow older, their own needs and preferences become a substantial change in circumstances. A parenting schedule that worked for a 5-year-old is often completely unworkable for a 15-year-old with a job, a driver's license, and a complex social life. In 2026, American divorce lawyers frequently deal with what is known as the mature child standard. While children in the U.S. generally do not have the right to choose which parent they live with until they turn 18, many judges will give significant weight to the preferences of an older teenager. The lawyer may request the appointment of a child representative or an attorney for the minor child to ensure the child's voice is heard without the child having to testify in open court against a parent. This avoids the psychological trauma of making a child choose sides, while acknowledging that a court order that ignores a teenager's reality is likely to be ignored by the teenager anyway. Modification of child support is another area where data drives the process. In 2026, most states use the income shares model, which assumes that children should receive the same proportion of parental income that they would have received if the parents lived together. As parental incomes fluctuate or as the costs of health insurance and extracurricular activities rise, the lawyer uses specialized software to run new child support guidelines. In many jurisdictions, if the new calculation results in a change of more than 10 or 15% from the current order, the court will find that a substantial change has occurred. This creates a cycle where parents may return to court every 2 to 3 years, just to keep the numbers accurate to their current financial reality. The role of the lawyer in these post-judgment battles is often as a gatekeeper of expectations. Relitigating a divorce is expensive, often costing between $5,000 and $20,000 depending on the complexity of the issues. A professional lawyer must advise their client on the cost-benefit analysis of the move. If Alex spends $10,000 in legal fees to reduce child support by $200 a month, it will take over 4 years just to break even on the legal costs. Furthermore, frequent trips back to court can lead to a perception by the judge that the parties are high conflict, which can negatively impact future custody decisions. In 2026, we are also seeing the rise of the digital modification. With the ubiquity of shared parenting apps, lawyers can now present hard data to the court regarding a parent's failure to exercise their time. If Alex consistently cancels their weekend visits via the app, Jordan's lawyer can export that data as a spreadsheet to prove a historical trend of abandonment. This objective evidence makes it much easier for a judge to modify the schedule to reflect the actual reality of the situation, rather than the aspirational schedule created during the initial divorce. The process of modification ensures that the legal system remains tethered to the actual lives of American families. It acknowledges that the only constant is change. But as we look at the intricate ways lawyers manipulate these rules and schedules, we have to confront a darker reality. What happens when the legal process itself becomes a weapon? What happens when a lawyer's ethical duty to their client clashes with the fundamental needs of a family? In the next part, we will pull back the curtain on the ethics and the economics of the legal profession itself. We will examine how the billable hour can incentivize conflict, the psychological burnout of the family law practitioner, and the specific red flags you must look for to ensure your representative is working for your future, and not just their own bottom line. The most dangerous person in the courtroom isn't always on the other side of the aisle. The most dangerous person in the courtroom isn't always on the other side of the aisle. To truly master the landscape of American family law, you must understand the economic and ethical machinery that drives the professionals themselves. In the United States, the divorce lawyer is governed by a set of rules known as the Model Rules of Professional Conduct, but they also operate within a business model that is fundamentally at odds with the quick resolution of conflict. The primary vehicle for this conflict is the billable hour. Most family law firms in 2026 operate on a 0.1 billing increment. This means that every hour is divided into 10 segments of 6 minutes each. If Alex's lawyer spends 30 seconds reading a one-sentence email from Jordan's lawyer, Alex is billed for 0.1 of an hour. At a rate of $500 per hour, that 30-second task costs Alex $50. If the lawyer answers 3 such emails in a day, that is $150. Over the course of a year, these micro-interactions can consume thousands of dollars from a retainer without a single motion being filed or a single asset being divided. This creates a systemic incentive structure that historical trends suggest can lead to a practice known as churning the file. Churning occurs when a lawyer performs tasks that are technically legal and procedural, but offer little to no strategic value to the client, simply to generate billable hours. Imagine if Jordan's lawyer suggests filing a motion to compel discovery for bank records that Alex has already offered to provide voluntarily in 2 weeks. The motion requires 3 hours to draft, an hour to file, and 2 hours of court time. Even if the motion is successful, the potential outcome is the same. Jordan gets the records. The only difference is that Jordan's lawyer has now successfully billed $3,000 for a result that was already available for free. A professional divorce lawyer must balance their ethical duty to provide zealous representation with the economic reality that peace does not pay the overhead of a law firm. The ethical guardrails intended to prevent this are strict but often difficult to enforce. Rule 1.5 of the Model Rules of Professional Conduct states that a lawyer shall not make an agreement for, charge, or collect an unreasonable fee. However, what is reasonable in a high-conflict 2026 divorce is highly subjective. Lawyers often justify high fees by pointing to the complexity of the assets or the recalcitrance of the opposing party. Furthermore, it is critical to note that in the United States, contingency fees in divorce cases are strictly prohibited by Rule 1.5d. A lawyer cannot say, "I will take 10% of whatever settlement I get for you." This rule exists to prevent lawyers from having a financial stake in the dissolution of a marriage or from discouraging reconciliation for their own profit. While this sounds like a protection for the client, it forces the billable hour model, which rewards duration over efficiency. Beyond the billing, we must examine the referral ecosystem or the divorce industrial complex. Top-tier divorce lawyers in 2026 do not work in a vacuum. They sit at the center of a web of forensic accountants, business appraisers, vocational experts, and private investigators. While these experts are necessary for a deep dive into complex estates, there is often a reciprocal referral system at play. A lawyer may consistently refer work to a specific forensic accountant, who, in turn, provides valuations that support the lawyer's preferred narrative. Case studies show that when these professionals work together frequently, they develop a shared shorthand that can lead to a confirmation bias. For Jordan and Alex, this means they are not just paying for a lawyer. They are funding an entire squad of experts whose combined hourly rates can exceed $2,000. The ethics of communication also represent a major pitfall. Rule 1.4 requires a lawyer to keep a client reasonably informed about the status of a matter. However, in the high-stress environment of 2026, many lawyers struggle with this. Imagine if Jordan sends an urgent text to their lawyer at 10 p.m. on a Tuesday because Alex is refusing to return the children. If the lawyer doesn't respond until Thursday, has the ethical duty been met? This delay is often where the lawyer-client relationship breaks down. Conversely, if the lawyer does respond immediately, the clock starts ticking at the after-hours billing rate. The most effective American divorce lawyers establish clear communication protocols in their initial engagement letter, specifying how and when they will respond to non-emergency queries to manage both the client's anxiety and their own billable efficiency. Conflict of interest is another area where the American divorce lawyer must tread carefully. Rule 1.7 prohibits a lawyer from representing a client if that representation involves a concurrent conflict of interest. In the legal world, this has led to a controversial tactic known as conflict out. In this scenario, one spouse, let's say Alex, calls every top-tier divorce lawyer in their city for a 20-minute consultation. Under the rules of confidentiality, once a lawyer has heard the details of Alex's case, they are often conflicted out of representing Jordan. While 2026 ethical rulings have cracked down on this as an act of bad faith, it still occurs in smaller jurisdictions where the pool of high-end legal talent is limited. If Jordan finds that every reputable lawyer in town is suddenly unavailable, they are forced to hire a less experienced representative, giving Alex a strategic advantage before the first document is even filed. We must also address the psychological state of the practitioner. Historical trends in the U.S. legal profession indicate that family law has some of the highest rates of burnout, substance abuse, and depression. Unlike corporate law, where the stakes are purely financial, family law involves the total restructuring of human lives. A lawyer who is burnt out may become cynical, leading to a cookie-cutter approach to cases. They might stop looking at the specific needs of Jordan's children and start pushing for a standard schedule simply because it is the path of least resistance. In 2026, a client must look for the red flag of a lawyer who is too busy to remember the names of the children or the specific details of the assets. To combat the opacity of the legal industry, 2026 has seen the rise of AI-driven legal auditing. Savvy clients are now using software to scan their legal invoices for block billing, where a lawyer lumps multiple tasks into a single 5-hour entry. These tools look for historical trends in billing. For example, if a lawyer bills 2 hours for researching the relocation statute for every single client, the AI flags it as potential double billing or inefficient work. This technological shift is forcing a new level of transparency on a profession that has traditionally been very protective of its ledger. As we look at the ethics and economics, we realize that the most successful outcome in a divorce is often achieved by the client who manages their lawyer as a project manager would manage a contractor. You must know when to authorize a fight and when to demand a ceasefire. But even with a perfectly ethical lawyer and a clear budget, there is one variable that no one can fully control: the law itself as it evolves in real time. In the next part, we will look at the cutting edge of American family law in 2026. We will dive into the legal status of digital assets, the complications of international jurisdiction in a remote work world, and how the system handles the division of unconventional assets like embryos and social media influence. The rules of the game are changing as fast as the technology we use to live our lives. We are entering the world of the 21st century asset. We are entering the world of the 21st century asset. In 2026, the American divorce lawyer no longer just looks for paper statements. They look for digital footprints. Consider the case of Alex's cryptocurrency holdings. 5 years ago, a lawyer might have asked for a Coinbase statement. In 2026, Alex is using decentralized finance protocols, liquidity pools, and non-custodial cold storage wallets. This creates a massive transparency gap. To bridge this, a professional divorce lawyer must now employ digital forensic specialists who specialize in blockchain analytics. These experts use specialized software to trace transactions from known on-ramps, like a bank account transfer to an exchange, out into the pseudonymous world of private wallets. The step-by-step process of uncovering these assets is grueling. First, the lawyer issues a subpoena to Alex's primary banks to find any outgoing wires to crypto exchanges. Once an exchange is identified, a second subpoena is issued to that exchange for all transaction histories and IP login logs. If those logs show that Alex transferred $500,000 in Ethereum to a private wallet address, the lawyer then uses chain-hopping forensics to see where that money went. Even if Alex claims they lost the private keys, a historical trend in 2026 courts is for judges to apply an adverse inference. If the money disappeared under suspicious circumstances right before the filing, the judge may count that value against Alex's share of the remaining tangible assets, effectively forcing Alex to pay for the hidden crypto with their share of the house equity. Beyond currency, we must examine the creator economy, which has become a billion-dollar battleground in family law. Imagine Jordan has spent the last 5 years building a lifestyle brand on platforms like TikTok or YouTube, amassing 2 million followers. In 2026, that account is not just a hobby, it is a revenue-generating business entity. The American divorce lawyer must now value influence. This is incredibly complex. Unlike a traditional software firm, Jordan's brand is tied to their face and personality. Jordan's lawyer will argue this is 100% personal goodwill, meaning it has no value without Jordan's active participation, and therefore cannot be divided. Alex's lawyer, however, will point to the enterprise aspects of the brand: the trademark names, the recurring brand contracts, the digital storefronts, and the team of editors and managers Jordan employs. Case studies in 2026 show that courts are increasingly treating these accounts as marital businesses. The valuation involves looking at the last 3 years of 1,099 NEC forms from platforms and sponsors, but also analyzing future engagement metrics. If the brand is growing by 20% annually, the potential outcomes for a settlement could involve Alex receiving a percentage of the channel's revenue for a set period, or a lump sum buyout based on a multiplier of the annual profit. The lawyer must also draft specific non-disparagement, clauses in the settlement to ensure that neither party uses their digital platform to destroy the other's brand value during the proceedings, as a single viral exposé video could bankrupt the very asset they are fighting over. The most ethically and legally fraught area of the 21st century divorce involves biological assets, specifically frozen embryos. In 2026, many U.S. couples like Alex and Jordan have turned to IVF to build their families, often leaving surplus embryos in cryopreservation. When the marriage ends, the question of what happens to these embryos becomes a collision between contract law and the right to procreate. Most fertility clinics require couples to sign a disposition agreement before storage, stating what happens in the event of a divorce. However, historical trends show that these contracts are increasingly being challenged. If Jordan wants to use the embryos to have a child and Alex does not want to become a forced parent, the legal battle is intense. Some states have passed legislation in 2026 that defaults to the party who wants to bring the embryos to term, while other jurisdictions maintain that no one should be forced to become a parent against their will. The lawyer's role here is to navigate equitable estoppel arguments. If Alex previously agreed to the IVF process and Jordan has no other biological means of having a child, the court may lean toward Jordan. This is one of the few areas of family law where the outcome is truly all or nothing, and the emotional stakes far outweigh the financial ones. Furthermore, we must address the digital nomad jurisdictional nightmare. In 2026, remote work is the standard for professionals like Alex. If Alex and Jordan spent 3 months in a van in Colorado, 4 months in a short-term rental in Portugal, and the rest of the year homeless but working for a company based in Delaware, where do they file for divorce? The American divorce lawyer must now be an expert in the Uniform Child Custody Jurisdiction and Enforcement Act, or UCCJA, and international treaties like the Hague Convention. The strategy involves forum shopping. Alex's lawyer will look for the jurisdiction that is most favorable to high earners, while Jordan's lawyer will look for the state with the most robust alimony protections. This leads to a race to the courthouse. If Alex files in a state with a no alimony trend before Jordan files in a more traditional state, the first to file often sets the jurisdictional home for the case. In 2026, we are seeing jurisdictional injunctions, where one state judge orders a party to stop a proceeding in another state, creating a legal gridlock that can cost tens of thousands of dollars just to decide which court has the right to hear the case. Finally, the 2026 divorce lawyer is increasingly using artificial intelligence as both a shield and a sword. Predictive analytics software can now scan thousands of past rulings from a specific judge to determine how they are likely to rule on a specific issue, like the valuation of a software firm or a relocation request. Lawyers use these probability scores to advise their clients on whether to settle or go to trial. If the AI shows that Judge Smith has a 90% historical trend of awarding 50-50 custody in move-away cases, Alex might decide that a 6-figure trial is a waste of resources. But as we look at these high-tech battles over crypto, followers, and embryos, we have to ask, what is the endgame? How does the American divorce finally conclude? And what does the new normal look like for the hundreds of thousands of families who emerge from this machine every year? In our final part, we are going to look at the post-mortem of the American divorce. We will discuss the long-term economic impact of gray divorce for older Americans, the psychological evolution of co-parenting after the lawyers have left the room, and the final masterclass secrets to ensuring that your divorce is a transition to a better life, rather than a permanent anchor to your past. The system is designed to divide, but the goal is to rebuild. How do you ensure the foundation is solid? We conclude the deep dive next. To understand the finality of the American legal process, we must examine the period known as the dust settling phase. For Alex and Jordan in 2026, the physical signing of the judgment was a climactic moment, but the psychological and financial fallout of that document will reverberate for decades. In the United States, the conclusion of a divorce case often triggers a phenomenon known as the standard of living drop. Historical trends indicate that following a divorce, the household income required to maintain the same lifestyle as a married couple increases by approximately 30 to 50%. This is the simple math of duplication. 2 mortgages, 2 utility bills, and 2 sets of household expenses where there was once one. For Alex, the high earner, this may mean a significant reduction in discretionary spending. For Jordan, it may mean a total restructuring of long-term financial goals. A critical and often overlooked segment of this industry is the rise of the gray divorce. In 2026, The United States is seeing a significant historical trend of couples over the age of 55 ending long-term marriages. Imagine if Alex's parents, whom we will call Bill and Susan, decided to divorce after 35 years of marriage. The role of the American divorce lawyer changes dramatically in this context. There are no custody battles over children, but there is a high-stakes war over the division of a lifetime of commingled retirement assets. The lawyer must navigate the complexities of Social Security benefits. In the U.S., if a marriage lasted 10 years or more, a divorced spouse may be entitled to receive benefits on their ex-spouse's Social Security record, provided they are at least 62 and unmarried. This does not reduce the benefit for the primary earner, but it is a critical piece of the financial puzzle that a lawyer must secure for a client like Susan, who may have spent years out of the workforce. As the legal proceedings conclude, the American divorce lawyer must guide the client through the mandatory estate planning update. This is where many individuals leave themselves vulnerable to catastrophic legal errors. In 2026, most U.S. states have statutes that automatically revoke the designation of a spouse as a beneficiary in a will upon divorce, but these laws often do not apply to non-probate assets like life insurance policies, 401k plans, or transfer-on-death bank accounts. If Alex were to pass away in 2027 without manually updating these beneficiaries, Jordan could still legally receive a multi-million-dollar payout, regardless of what the divorce decree intended. The lawyer must provide a step-by-step checklist for the post-divorce transition, updating the power of attorney, the healthcare proxy, and the successor trustee for any existing family trusts. Furthermore, we must address the evolution of the co-parenting relationship from a litigious model to a business model. By 2026, the American legal system has increasingly moved away from the courtroom as the primary site for resolving minor disputes. Instead, lawyers are now frequently incorporating a parenting coordinator or PC into the final judgment. A PC is a quasi-judicial professional, often a senior family law attorney or a psychologist, who is granted the authority by the court to make binding decisions on the day-to-day minutiae of a parenting schedule. If Alex and Jordan cannot agree on which summer camp the children should attend or what time a holiday pickup should occur, they do not call their lawyers to file a motion. They call their PC. This professional listens to both sides and makes a decision in real time. This historical shift saves families thousands of dollars in billable hours and prevents the court docket from being clogged with haircut motions or soccer practice disputes. The long-term economic impact of the American divorce lawyer's work is also felt in the management of legal debt. Many middle-class families in 2026 find themselves emerging from a contested divorce with significant credit card debt or personal loans taken out to fund the litigation. A professional masterclass on this topic would be incomplete without discussing the strategic use of the attorney fee award. In the U.S., if there is a significant disparity in income between the parties, such as the gap between Alex's $250,000 salary and Jordan's $40,000 earnings, the court may order the higher earner to pay a portion of the lower earner's legal fees. This is not a penalty. It is an attempt to level the playing field so that justice is not simply bought by the person with the largest bank account. However, these awards are rarely 100% of the total cost, leaving both parties to navigate a post-divorce world with a litigation tax that can take years to pay off. In the final analysis, the American divorce lawyer acts as the architect of a new reality. They take the wreckage of a failed emotional contract and attempt to build a functional legal one. For Alex and Jordan, the success of their new normal depends on how well the lawyer anticipated the future. A well-drafted 2026 judgment includes anti-cohabitation clauses for alimony, right of first refusal clauses for childcare, and specific protocols for digital inheritance. These are the granular details that prevent future conflict. If the lawyer fails to address who gets the family dog or how the Children's College 529 plans are managed, they have essentially left a ticking time bomb in the lives of their clients. As we look toward the future of the profession, we see a move toward unbundled legal services. This is a growing trend in the United States where a client hires a lawyer for a specific task, such as drafting a motion or attending a single mediation session, rather than a full-scope representation. In an era of high inflation and rising legal costs, this lawyer a la carte model allows more Americans to access professional counsel without the traditional $20,000 retainer. However, it also places more of the administrative burden on the client, who must act as their own paralegal. This democratized version of family law is still in its infancy in 2026, but it represents the most significant shift in the delivery of legal services since the introduction of no-fault divorce. Case studies of successful divorces in the U.S. reveal a common thread. The parties prioritize the preservation of capital over the vindication of ego. The lawyer's most valuable service is often the one the client wants the least. The cold water, advice that their position is legally weak or financially ruinous. When the final part of this masterclass concludes, the viewer should understand that the legal system is a tool for resolution, not a weapon for revenge. The American divorce lawyer is the navigator of this system, but the client is the one who has to live in the house they build. The story of the American divorce lawyer is a story of how a society manages its most intimate collapses. It is a world of forensic accounting, psychological evaluations, and the relentless pursuit of an equitable outcome. But as we see the conclusion of this deep dive into the litigation side of relationships, it raises a new and perhaps more vital question. If the cost of ending a marriage is this high, emotionally, financially, and legally, then why are we so ill-prepared for the beginning? The ultimate protection for your future isn't a good divorce lawyer. It is the document you sign before the wedding even begins. In our next Deep Dive Masterclass series, we are going to explore the high-stakes, controversial, and often misunderstood world of the American prenuptial agreement. We will look at how to protect the assets you haven't even earned yet, and how the laws of 2026 are making these legal insurance policies the most important contract of your adult life. The game of protection starts long before the end,